Good morning, everyone, and welcome to our webinar this morning. We're going to just give people a couple of minutes to join us for this morning's session. And while we're waiting for everyone to join, let me introduce what we're going to be looking into today. Our session today is all about branding and a legal guide for business owners. My name is Leah, and I am here from Invest Ottawa. Thanks to the support of our partners that you can see here on the slide, we're able to be here today and offer you a free webinar. We're also able to provide you with free programs that run throughout the year and business consultations with an expert in the field. So if you're interested in any of these services, you can find more information on our website, or you can also reach out to me after today's session. Which brings me to a couple of house rules for today. Everyone here, their microphones are muted and your cameras are turned off, so the focus truly is on our speaker. If you have any questions, and I highly encourage you to ask them, please use the Q&A function that you can see at the bottom of your window. Like this, we'll be able to answer your questions as we go and truly make this your session and answer the questions and thoughts that you might have on this branding big topic we're going to be looking into today. And that brings me to our speaker. It's my absolute pleasure to welcome Jamie-Lynn Kraft. Jamie-Lynn is here from our partner Smart and Biggar, where she is a senior associate. So thank you so much, Jamie-Lynn, for being here today, walking us through branding, what we need to consider as business owners. And I'm just going to hand it over to you. The floor is yours.
Great. Thank you very much, Leah. It's great to see everyone today. I see we have about 15 participants. So I'm very excited to chat with you about my passion, which is branding from a legal perspective. So if you'll bear with me one moment while I share my screen so you can see my slides, I will do that. All right. So Leah, can you just nod so let me know that you can see my screen? Yeah, thumbs up. We're good to go. Wonderful. All right, everyone. So this is an outline of what we're going to be talking about today. I'm going to do an introduction to me. I'm going to get a little bit of an introduction from you. I'm going to discuss why brands are critical, how you can choose powerful trademarks, how to protect those in a global marketplace, and how to create exclusivity in a crowded industry using your brand. So Leah gave a brief introduction to me and my firm. I'll go into that a little bit in a little bit greater detail. Smart and Biggar is Canada's largest firm, which is devoted exclusively to intellectual property and technology law. So we are what's called a boutique law firm, and that's all that we do. So we're specialists in the area, and we are located across the country. Ottawa is our head office. We also have offices in Toronto, Montreal, Vancouver, and Calgary. And me, I am a lawyer and trademark agent, which means that I help clients with their trademark strategy, their trademark selection, protecting their trademarks through registration, and then enforcing those trademarks. So who are you? I'd love to know. Whenever I've given this masterclass before, and I find that it's always very helpful for me to get a sense of where you find yourselves in terms of your intellectual property, branding, and trademark knowledge. So with that, I'm going to have our first poll question of the morning. And can you tell me how familiar you are with intellectual property? You're very familiar, you have direct experience, maybe someone sent you a demand letter that you replied to, you're somewhat familiar, you've heard the terms before, and you have a general understanding, not very familiar, or not at all familiar. And so that's great. You know, all levels of knowledge and expertise are welcome. So far, we have I think we've got everyone who has responded. So I think we can end the polling around now. And I'm just reading the results. I'm going to put them on my main screen, so I'm staring at the camera at the same time. Okay, it looks like the majority, about half, a little more than half of you are somewhat familiar with trademarks. You have a general understanding of trademarks, patents, and copyright, but a couple of you are, not as comfortable. So that's great. I'm hopeful that my talk here today can address both the basic understanding of intellectual property as well as some more advanced topics, so that it can be of value to all of you. Okay, so I'm going to close this poll now. And moving on to, what is a trademark? Well, a trademark is a legal definition. Uh, and we have an act, a piece of legislation in Canada, which is called the Trademarks Act. And under that piece of legislation, there is a legal definition for what a trademark is. And essentially, it is a sign or combination of signs, which is used for the purposes of distinguishing the goods and services from one party from the goods and services of another. So it can be a word, a personal name, a design, a letter, a number, a color, a three-dimensional shape, a hologram, sound, scent, taste. When we think of trademarks, the conventional ones are the words, the word McDonald's, or the designs, the golden arches. But they can be any one of those signs that you see here on the slide. But the key element of what a trademark is its ability to distinguish. So it is distinctive and can distinguish. So when I look at a can on the shelf, I see it's my trademark and not someone else's trademark. So what is not a trademark? So when we talk about intellectual property, sometimes the terms can be a little confusing because there are a lot of them. Well, a trademark is not a trade name. The trade name is the name under which a business is carried on. That can sometimes incorporate a trademark. So the word McDonald's is used as a trademark for the services of providing restaurants, but it's also the name of the company is McDonald's. So in that case, the trademark and the trade name are the same, but in some cases they're different. So we think of Apple, the technology company, that's the company name. And then they have a product called iPhone, that's the trademark. So there can be a distinction between a trademark and a trade name, but in some cases it can be the same word. A patent, well, a patent is not a trademark. A patent protects a new, useful, non-obvious invention. And so we think about pharmaceutical patents. So the pharmaceutical, the chemical compound which makes up a pharmaceutical product, that can be the subject of a patent. And if you have a patent, then you have the exclusive right to sell that invention, or to license it to others. Trademark is not a copyright. Copyright is the protection of original works. So those would be written works like books, scripts, artistic works like paintings, photographs, musical works, songs, scores. And so it's the protection of the expression, the expression of the idea, and not the idea itself. And the trademark is not an industrial design. An industrial design can protect the appearance of a product. And sometimes an industrial design can obtain trademark protection as well. I'm trying to think of an example that I could give you. So if you imagine the old school Jaguars, the cars, they would have on the hood the ornament of the leaping jaguar that would be on the hood of the car. That could be the subject of an industrial design. And after a number of years, if customers begin to associate that physical three-dimensional shape on the top of a car with the company Jaguar, then you can develop trademark rights in it and actually obtain a registration as well. So that's a little bit of an interplay between industrial designs and trademarks. Other examples of industrial designs would be the user interface of an app. That can also be the subject of an industrial design registration. So we talked about trademarks, which are a legal concept, and then the topic of this masterclass is branding. So what's the difference between a trademark and a brand? Well, a brand is generally understood. It's not a legal concept. Branding, it's more of a marketing concept, and it's generally understood to be the overall experience of a customer, which distinguishes the organization from its competitors in the eyes of the public. So that can be, it can include the trademarks like the names, the logos, the slogans, but it also is the font, the styles, and certain intangibles, like what is the corporate culture? What is this company known for being about? And the brand really taps into consumer emotions, and because of that, it can be a commodity. So trademarks and brands are very much interrelated. The trademark is a key element of a brand, and it's the vehicle. Trademark rights are the vehicle through which you can protect and enforce your brand, which we're going to talk about later on in this topic. So why are brands critical? Well, this brings us to our next couple of poll questions. I've got some brands here on the screen, and I'm going to try to get you to guess what company, which trademarks these brand logos belong to. So we've got the three options on the screen here, and you've got your three polling in progress. So number one, is that the logo for Budweiser, Coors Light, Sapporo, or Heineken? Number two, is that the logo for Coca-Cola, Pepsi, Sprite, or Dr. Pepper? And number three, is that the logo for McDonald's, Taco Bell, Burger King, or Wendy's? All right, we've got, it looks like, we've got more people responding now. Okay. At first, it looked like everyone was having the same answer, but now we've got some disagreement among the attendees. So I like that. I like to see that. So I think we're going to give 10 more seconds, and then we're going to close the poll in case someone wants to change their answer. 3, 2, 1. All right, we're going to close it. We're going to close the poll. So number one is indeed Heineken, and most of you got that right. A vast majority of you recognize that's the Heineken logo, even though the word Heineken was not obviously where you would normally find it. And again, similarly for the second logo, most of you knew that that's the Coca-Cola, the red background, the white swoosh. And then finally, Burger King. Oh, looks like I have a typo in my poll answer. Despite the typo, most of you knew that was Burger King, not Burger Kind, and not one of the other fast food restaurants. So that's a fun little exercise that I like to do, just to show that I took away the words. I took away the company names, the main house trademarks, and I just showed you these logos in the abstract. And most of you were able to look at the logos, and you still knew what the source was. And that's powerful. That means that these companies have spent a significant number of resources to make sure that the public recognizes their brand elements. And brand value is actually a line item in a company's books, and it can be a significant line item with the number, the value that is attached to it. So this list here just shows you that brand has value. So this is the 10 most valuable brands in the world in 2020, based on their brand valuation. So not based on just their revenues or their sales or some other factor. It is when they look at the brand value in their balance sheet, how much is that worth? And it's in the hundreds of billions for some of these companies. So that's astounding. And it just goes to show that if you have a powerful brand which you enforce and protect, then that adds overall business value. It's a line item on your balance sheet. That's worth something. And of course, I'm sure that you've heard of most, if not all of these brands because of that brand value. So aside from that, why are brands critical? What can they specifically do for you as a business person? Well, they are first and foremost a marketing tool. And what do I mean by that? Well, it's a way that you differentiate your products from your competitors' products. So Pepsi and Coke, their logos, the words are different, the logos are different color schemes, different types of commercials, and it's through those differences that they distinguish each other. They distinguish themselves from each other, so that a customer knows that when they go to the store and they pick up the blue bottle or the blue can, that they are getting the Pepsi Cola, and if they pick up the red can, they're getting Coca-Cola. Second, a trademark registration can be a method of risk management. So if you obtain a registration for your brand name, it is proof that the brand belongs to you in the country where you've obtained the registration. So let's say Canada, and that you now have the right to use that trademark with your associated goods and services throughout all of Canada to the exclusion of all others. So that means that you can't be stepping on someone else's toes because you have a registration that gives you that right. And that is also an enforceable right that you can assert against others. So you can take you have your brand and it's protected by your trademark registration. And if someone comes along and does something which is too similar to you in terms of their branding, well, you can use your trademark rights, including your registration, to stop them. You can say, I see what you're doing. It's going to cause consumer confusion. I have rights here. Stop, or I'm going to sue you. And sometimes it goes all the way to court, and a judge will decide. And a trademark brand and an associated trademark registration can also be a revenue tool. So it can be licensed to others. So if you think of sports organizations, for example, like the Ottawa Senators, they're not in the business of making hats and selling Coke, but they partner with other companies and grant those companies the rights to use the senator's name and the senator's logo in selling their products. And in doing so, they receive royalties, licensing revenue. So trademarks can also be a revenue tool for that reason. So you can think of your brand as an asset, and you can think of your trademark registration as the bucket that holds all of that value that you're building in your brand. So all of that consumer recognition, all of the sales revenue, it's going into that bucket, and then the registration is the deed. It's the certificate of ownership, which says I own this brand and this brand has value. So then what you can do with that asset is if you're at the stage where you're looking to be acquired, and there's going to be an evaluation of your business, well, then the brand value, which is protected by the trademark registration, is an aspect of that valuation. Similarly, maybe you're not looking to be acquired, but you're looking for investors or to secure credit to get more financing. Again, those investors, those creditors are going to want to look at what's the brand value and is it protected by our trademark registration. And it can also be used for transfer pricing arrangements. I'm not going to go into this in too much detail because if you're at the early stage of your business, it's probably not going to be relevant. But I'll just explain it very briefly. You can. There are different tax rates in different countries for companies, and so some countries, you think of maybe like the Cayman Islands or something, have very low tax rates. And some other countries like Canada have very high tax rates. And companies can shift their tax burden by having multiple subsidiaries in different jurisdictions. And they can have, let's say, the low tax jurisdiction owning all the IP, so owning all those trademark registrations, and then licensing it to the operating company in Canada, let's say, to use those trademarks. And they do that in exchange for a royalty fee. And then what happens is that the taxable profits are then shifted to the low tax jurisdiction. Anyway, I don't do much transfer pricing, but that's just my general understanding of the situation. And it just goes to show that when you become big enough that you're become a multinational corporation, those brands and those associated trademark registrations can have an additional value in being able to shift your tax burden around. All right, so I'm just going to pause just in case there's any questions about the first topic, which is why brands are powerful and why they're critical. And then we'll move on to how to choose a powerful trademark.
I don't have any questions on my end at the moment, Jamie-Lynn, and I just want to use this opportunity for everybody that's here on the call. Please ask your question. You can use the Q&A function. Jamie-Lynn is really here for you today and the questions you might have when it comes to everything that she's going to be walking through with you today.
Great. Thank you, Leah. All right. So for now, we'll move on to the next topic. But of course, if questions come up that relate to the topics I just discussed, don't hesitate to ask.
As we were talking, Jamie-Lynn, we actually do have a question that came in.
Okay, great.
And the question here is from Nancy. Does the brand is the brand protected internationally?
Okay, that's a really important question. I do have I have a section later on in my talk about how to protect your marks globally. But very briefly, I'll answer your question now. Your trademark rights are protected wherever you have sought to protect them. So in places like if you're operating in Canada and you apply for a trademark registration in Canada, your brand is protected in Canada. If you are using in other jurisdictions, so let's say you're operating in Canada, but you also have many customers in the States and you've been selling to the United States, well, you might also have some protection in the United States by reason of that reputation. And if you wanted to enhance that protection, you could secure a registration in the United States separately. So it is really a jurisdiction by jurisdiction process, and I'm happy to discuss that in the next section. But that's just to give you a little bit of a teaser on that point.
Amazing, thank you. And then I have another one here from Kelly. Do you think that trademarks are important for a small business?
Absolutely. I absolutely think trademarks are important because really any business, if you're going to succeed, you need to be able to differentiate yourself. So you want to have a brand, a brand and trademark, which is distinctive and stands out from the crowd. And so you don't necessarily need a registration at that point, and we can talk about that in a little bit later about when it's a good time to file for a trademark registration. But I think you just naturally, I think many times in a small business, the cart comes before the horse. Your business is coming together and you already have your name planned, and you're thinking of it as, this is my name, this is my brand, but you're not actually thinking about it in the legal terms of, oh, this is a trademark which I need to now protect. So from a business perspective, absolutely, trademarks are important just in terms of differentiating yourselves from your competitors. And then as you go down the road, trademark protection becomes more important. But you want to think about protection from the start during the brand selection process in order to avoid running into difficulties. And so I'm going to talk about that in a little bit when we talk about how to choose a powerful trademark. And so even if you are a small business, you don't want to get that dreaded cease and desist letter from the big company saying, oh, you're not supposed to be using that trademark. So we'll talk about that in a little bit. So short answer is yes, I think trademarks are important for small business.
And then a last one I have here from Nancy, and probably you're going to be touching up on this later, but how much does it cost to register a brand in Canada?
Okay, all right. That is a really good question. And I think that it probably will be better for me to answer that later once I've given a more thorough explanation of where and when you should register. But I will definitely, if I don't answer that question, please remind me. But I think that it will be better answered later on. All right.
Perfect. That's it. Thank you.
That's it. Okay, we'll move on to the next topic then. And it does sound like I'm very pleased to hear your questions, because it sounds like I have already anticipated some of them, and we'll be able to answer them in the later part of the masterclass. So, how to choose a powerful trademark. So you've heard me say today things like you want to distinguish yourself, you want to be a differentiator, you need to be distinctive. All of these words are the point of them is that you need to stand out. And what do I mean by that? Well, a powerful trademark is one which doesn't really tell the consumer what the goods and services are. So I really like using this visual aid on the slide you see here, which is the inherent distinctiveness scale, I like to call it. So it's the inherent distinctiveness is a legal term. And essentially what we see here is at the low end of the scale, we have marks which have no inherent distinctiveness. This means that these are marks which there's nothing about them which points to a single source. So think of marks which are really descriptive. So a mark like hardwood chairs, when you're selling chairs made of hardwood, a consumer, if they're in a store and they see that chair and they see that it says hardwood chairs on it, they're not going to understand that that is a trademark or brand of a business. At least not unless someone has spent millions and millions of dollars in advertising their brand hardwood chairs. They're like, oh, this is I know hardwood chairs. I know of them. But if they've had no prior knowledge, just looking at the word hardwood chairs on that chair made of hardwood, they're just going to think it's a description. They're not going to think it's a trademark. They're not going to understand that that is a source indicator. So those are not very strong marks, and it's not a good idea to adopt them because it can be very difficult to get any brand recognition, and they're very difficult to protect. So if we move along the scale to suggestive marks, so we think of cool kids, even if it's both written with K, for children's clothing. Well, it doesn't specifically say clothing in the mark, but I can, if I see a piece of clothing that says cool kids on it, I'm like, oh, well, maybe this is just supposed to be, for kids and it makes them look cool. It's probably something that is capable of trademark protection. It can be a brand, but it's very weak and it'll be very difficult to protect because you're not going to be able to stop other people in the clothing business from using the word cool. Probably. I imagine that it's just it's a laudatory term that other people should be able to use. Cool means that something is interesting or neat. And kids for children's clothing, again, that's very descriptive. And so your competitors of children's clothing are going to be able to use the word kids. So then we move along the spectrum further, and now we have distinctive trademarks. So think of arbitrary words. So words which are in the dictionary, they have an ordinary meaning, but when you apply them to a particular product, they make no sense. So an excellent example is apple, which is an ordinary dictionary word meaning a piece of fruit, for computers. Well, what does apple have to do with computers? So all of a sudden, you've taken an ordinary word, put it with something completely arbitrary, and it becomes incredibly strong, inherently strong. Obviously, Apple is a strong brand because of all the advertising that they do on top of that. But before they even spent a single penny on advertising, Apple was a strong trademark inherently. And then we move all the way to the end of the spectrum, which is coined words like Kodak and Xerox. Xerox is a special case because you might have heard the word Xerox being used to describe the process of photocopying, but that's just because they didn't protect their brand from becoming generic. We'll discuss that later on. But Xerox is a completely made up word that has no meaning whatsoever, similar with Kodak. So those marks are very strong. So distinctive and strong marks, those are highly advisable because you immediately get brand recognition, and they're easier to obtain registered trademark protection for, because the Canadian Trademarks Office and similar offices around the world won't actually allow you to have a registration if you have no inherent distinctiveness, if you're clearly descriptive. And even sometimes if it's a weak mark, they won't let you have the registration. And then their strong marks are just easier to enforce. So if someone comes along, and even if they're not using something identical, but it's similar, well, if your mark is strong, then you have a broader scope. Whereas with those weak marks, really the scope of your protection and ability to stop other people from copying you is just with that exact same word. So strong trademarks are coined words, arbitrary words, unusual grammatical structures, rhyming, and novel and creative designs. Those are typically strong trademarks. And then weak trademarks would be descriptive words, laudatory words like super, best, premier, ultra, max, cool, neat. Slogans like freshest coffee in town. That would be a slogan that's inherently weak because it's telling customers what it is that you are promising to offer them. Personal names and surnames are weak, and geographic names. So, but it's important to remember that yes, when you're starting off, ideally you choose a strong mark, but even if you're choosing a weak mark, it can still be protected and it can have value. It just takes more effort. So Amazon, that's an incredibly valuable brand. It was on our list. It's a geographic word. Inherently, it's actually a weak mark, but it has become very, very strong over time. iPhone is another example of a very weak mark. I means internet and phone means phone for phones that can connect to the internet, but incredibly strong mark because of all the branding that has been done. Because of all the marketing, pardon me, that has been done to enhance the strength of the brand. But that takes a lot of money and a lot of time and a lot of effort. And ideally, you would choose a strong mark, and then the marketing would follow, and you would have something that's strong inherently and after all your promotional efforts. Before I move on to searching, is there any other, do we have any additional questions on the choice of strong versus weak marks and what that means?
I have a question here from Nancy, whether that name is distinctive or not. The name is Fika Fun Times. It's an activewear and casual clothing brand.
Okay. It's hard to say about, without having, considered it in great detail, but I don't know what the word fika means. To me, that comes across as being distinctive and would therefore be strong. Fun times probably is a weaker part of the mark, but if you've got that word in there that doesn't really mean anything, and I'm just assuming that to be the case, then yeah, that could be pretty strong. So that would be an example of a stronger trademark.
That's it for now.
Okay, great. So, we talked about, let's pick strong trademarks. Let's pick ones that are, arbitrary or coined. Well, we also want, when we're in the selection process, we also want to do searches to make sure that we're not going to be infringing someone else's rights. And that is very important. And searching can also help you identify whether a word is weak or strong. So it could be the case that you think that a word is inherently is distinctive, it's arbitrary, why would anyone else be using this term? But then you could do a search and find out that actually everyone in the field is using this word, and so you're not going to be able to protect it. So searching can be helpful in order to it can be helpful in choosing strong marks. Searching can also be helpful in avoiding liability. So, what do you mean by searching? How do I search? What should I be doing? Well, this is something that you can do yourself, and you can do in conjunction with a trademark agent or lawyer. So uh, the easiest way to do it is to just do some internet searching. Go onto Google and type in your proposed mark and maybe your goods and services and maybe the countries where you're planning on using it. So, um, you know, uh, Apple computers, Canada, and if something comes up which looks like a competitor is using the same mark or a very similar mark in the same space as you in Canada, then you're going to want to steer clear of that. But if your internet searching comes up clear, then you can do a little bit more poking around, a little bit more thorough of a search at that point. Let's say you've got your three options or your 5 options, and you've done your internet searches, and you've weeded it down to 2 or 3. Well, then you can go to your in-house legal team, which I understand in many cases for small businesses, you're the marketing team and the legal team. Well, then you can go and do your own dead hit or essentially an identical search on the Trademarks Office databases, which are of interest to you. So if you are a Canadian company and you plan to be selling in Canada, well, then the Canadian Trademarks Office database is where you want to be searching. So this is a website run by the Government of Canada, which is publicly available. You don't need a subscription. You just hop online. You can find it, type into Google Canadian trademark search and go to the Government of Canada website. It's easy enough, and you can just type in the word that you're searching for, and you can trademark. You can narrow it down. Like, I'm looking, the trademark is this, and then you can also search by goods, and you can play around. But essentially, what you're looking for is any identical marks. And if nothing pops up, well, that's great. If some pop up, but then you go and you open the registrations and see, oh, well, no, this person is offering medical equipment and I'm going to be selling lollipops. Well, completely different, probably irrelevant. And at that point, maybe you feel that you're comfortable proceeding with the mark, knowing that you've done your internet searches and nothing came up. You did your dead hit searches at the Canadian database or maybe the US database and nothing came up. Or if you have a little bit more of a budget and you have less risk tolerance, maybe at that point you get a law firm involved. And a firm like ours can do a more comprehensive search, which is we do a search of the database, of the Canadian Trademarks database, for example, and we try to your search, the one that you do on the online database, is only going to find really identical hits or marks which are containing the words that you've searched for. Our searchers, they can use some more sophisticated search operations to identify other marks, which, while not identical, could still pose a problem. And what we're looking for, what we're assessing is there going to be consumer confusion? And when we talk about consumer confusion, we say, how similar are the marks in appearance, sound, or ideas suggested? So an example would be purple butterfly versus violet moth. They look and sound completely different, but they convey a very similar impression. Those could be confusing if the goods and services are the same. So we also look at the goods and services. Apple Auto Glass can coexist with Apple computers, because the services of a windshield repair company are not similar at all to a computer company, and so there is no consumer confusion in that case. So we can do some more sophisticated searches and conduct that confusion analysis, and then law firms can also do a comprehensive search, not only of the Trademarks Office database, but of what we call it a common law search. And that means that you search for use of trademarks which might not have been filed or registered in Canada, because in countries like Canada and the United States, trademark rights can arise through use and reputation. You don't need a registration in order to have rights. And what that means is, if you are selecting a new trademark, And you could search the database, the Trademarks Office database, and find no confusing results. And so you launch your new brand and you start selling your products, and all of a sudden you can receive a cease and desist letter because for the past 20 years, someone else has been using the exact same mark with the exact same goods, but they haven't bothered to file a trademark application. But they still have rights that are better than yours, and they can sue you. So in countries like Canada and the United States, if this is a mark in which you're going to be making a significant investment, if it's going to be expensive to rebrand, if it's going to be embarrassing, then it's a good idea to do a full Trademarks Office database plus common law search to really try to find, to make sure, to give yourself a better indication that you're not going to run into someone else's rights. But again, that's also, it depends on the budget. Yeah, at the early stages, there's usually not a budget for searching. Just to give you I know that there was some questions about fees for filing and registering your trademark. Well, if you're going to involve a law firm for searching, obviously there will also be fees for that. So for us to do the Trademarks Office comprehensive search in Canada, the cost for that is about $1,000. And if you're going to do the comprehensive full Trademarks Office plus common law search and provide our opinion to you, that's more in the range of $2,000. So that's from the beginning. And it could be the case that the answer is no, this is not a good mark, and so you have to do it all again. So that's why if you do have the budget and you're going to involve a law firm, it's a good idea to do your own due diligence first, just to weed out any obvious conflicts, so that you don't waste your fees, your legal budget on a mark that was really never going to have a chance. Are there any other questions right now?
No, I think you went through the one we had here. If there are any other resources than doing the Google search, and you just mentioned all these different aspects.
Okay, great. Yes, wonderful. So we can move on now to protecting trademarks in a global marketplace. And I know from some of the questions that was a topic that you are interested in. So here we go. So different types of protection. When I was talking about searching, I just mentioned that trademark rights can arise through use and registration. Well, so let's look at Canada, for example. Trademark rights can arise from registration, which means you file your application with the Trademarks Office. And what is the application? Well, it's an online form, and it says, here's my trademark. Here is me, the applicant, that I'm claiming to own this. And here are the goods and services with which I intend to use the trademark. And then you submit, you pay the fee, you submit it, and the office, the Canadian Trademarks Office, which is a branch of the government, they will review the application. They will conduct their own searches of their database to make sure that there's no confusion. They'll look to make sure it's not clearly descriptive. They're not going to give you hardwood chairs for hardwood chairs. And if everything appears to be in order and there's no inherent distinctiveness issues, if there's no confusion issues, then they'll approve the application. It will be published for opposition purposes, which means that third parties have an opportunity to say, hey, you don't get to have that registration. That mark is too close to mine. But if you pass through that successfully, then you get your registration. And so you have this certificate from the government of Canada, which says you, the applicant, the owner now, the registrant, have the right to use that trademark with those goods and services throughout all of Canada to the exclusion of all others. And so protection across the country. If you were to sue someone for using a confusing trademark, you have a greater chance of success with the registration, because all you need to prove is confusion. There's passive enforcement. So what does that mean? Well, we just talked about searching. And so now you have your mark on the register. In fact, before you even have your registration, it's showing as a pending application. And so someone else later decides to do their search because they're starting their branding efforts. And oh, well, they see that your mark is there. Oh, well, they're going to stay away from that because they don't want to receive a cease and desist letter from you. Or let's say they didn't search, they file their application after you did. Well, I mentioned that the Trademarks Office is going to conduct their own search and they won't allow that application through if they find a confusing mark. Well, in that case, it might be your confusing mark. So you don't even, in that case, you didn't even know that there was someone else out there who was trying to use a confusing mark. Just by virtue of having your application or registration on record, people were staying away from you. It can also be a defense to a claim of infringement from someone else. We talked about that at the beginning, how a trademark can assist with risk management. And registration is available almost everywhere in the world. So you can get a registration in Canada, the United States, the European Union, each of the individual countries in the European Union, all across the different countries in Africa, China, all around the world. These are available. And once you have, and many countries, your rights begin to run from the date of your application. So not the date of your registration, but the date that you file your application. And then in Canada and the United States and a couple other countries that I can't remember off the top of my head, you can also have rights by virtue of using your trademark, so selling products or offering services in connection with that brand, pardon me, and developing this reputation. That in itself is protectable. And what that means is, so let's say you don't have a registration, but you find someone is opened up a shop just down the street from you selling the same products under a really, really similar mark. Well, you could, if you had a good claim for that the mark is confusing, you could sue them for what's called passing off. That's the legal term. So it's not trademark infringement because you don't have a registration, it's passing off. But that can be more difficult because you have to establish in that lawsuit that you have a reputation, which you don't have to do if you have a trademark registration. And it can be very expensive and time consuming and difficult to meet that burden. But it is a right that exists. So you can take some comfort. And your rights begin to run from the day that you use. So even if you file your application later, you still have better rights than anyone else who files their application or uses after you started using your mark. But that's only available in countries like Canada and the US and some other Commonwealth jurisdictions. So, it's important to know that in Mexico or China, Japan, these are first to file countries. So if those are important for you and you have been selling there, then you're going to want to give some serious consideration to filing in those countries and obtaining registration, because you don't have rights just by virtue of using. But in Canada and the United States, you can wait a while to file the registration because you know that your rights exist by reason of your reputation. So, well, how do you develop your filing strategy? Well, you do a cost-benefit analysis. So you might just have one brand. It's your company name, and that's your only trademark that you have. Well, that's number one and the most important. But it might be the case that you have your company name and you have a whole line of products, and each product has its own different brand name. And then maybe you have some slogans as well and some logos. So you might have multiple different brand elements which could be the subject of trademark protection. Do you file for all of them? Which ones do you file for? When do you file? Well, rank them in order of importance and risk. So which is your most important brand? Which is the one that you'd be most upset if someone was to copy? Which is the one that you're generating the most revenue from? And then also rank them in terms of risk. Is it a really ingenious name that you'd be worried someone else is going to copy? Is it something that you would be most concerned about? Is it something, in fact, if it's a strong mark, the risk is probably less. If it's more of a weak mark, the risk is probably higher. And in those cases, you might want to register sooner in order to prevent your competitors from getting too close by using similarly suggestive words. Then you want to rank your countries by order of importance and order of risk. So where are your sales coming from? If you're a Canadian company, but 90% of your sales are to the US, then file in the US first. It's a bigger market. It's obviously more important to you. And if budget's limited, then really that's where you want to spend those filing dollars. Well, conversely, if it's Canada as your number one market, then file there. And then you can always file in countries later. It's just, there's a risk that someone else could get in there before you. And so again, you want to rank the countries by risk as well. So we know that China has a counterfeiting problem. Let's say your products are produced in China, but you don't sell there. Well, you might want to consider getting yourself a registration there to prevent someone from starting to sell counterfeit products, or even filing an application to register your mark before you do. That happens in China all the time, and there's nothing that can be done just to stop that if you don't get your application in first. So, rank your countries in order of importance and risk. And overall, just let your sales drive your protection. So if the sales are pointing towards this one brand in this country, that's where you want to direct your protection dollars first. And then it sort of trickles down from there. There's a point on the bullet point on this screen that says priority can buy you some time. You're probably wondering what on earth that means. Well, you can file in one country. So let's say you're a Canadian company. You can file your application in Canada because it's very important to you, the Canadian market, to register your trademark. And you can wait up to 6 months before filing in any other country in the world, almost any other country in the world. And by reason of a treaty, which most of these countries have entered into, your foreign applications get to be backdated to your Canadian application. So you file in Canada, and then 4 or 5 months from now, you file in China. Well, China's a first to file country. And let's say someone else in China filed in that interim between your Canadian filing and your Chinese filing. Well, that doesn't matter. Your Chinese application is backdated to your Canadian application, and you have priority to the Canadian application, which boots that other person out of the way. So priority can buy you some time. So you have 6 months within which to decide where else you want to file to take advantage of that Canadian filing date. You can still file in other jurisdictions after the 6 months. There's nothing to prevent that. You just don't get that early Canadian filing date, which can be critical in first to file countries. You can also take advantage of the international registration system. So this is another mechanism which is available by reason of treaties that Canada has entered into. So you can have your Canadian application, or let's say you've already obtained your registration, and now you want to go and obtain protection in other countries. Well, you can go into those other countries individually, and you can hire us, like hire a law firm to go and do that for you through our connections in other countries. Or you can use the international filing system. And what you would do then is you take your Canadian registration and you file an application with the Canadian Trademarks Office saying, Canadian Trademarks Office, please file my international application based on this Canadian registration. And please file it in, and please designate these 5 countries: the United States, the European Union, the UK, Australia, Brazil. Those are, or Mexico, let's say. Those are the countries. So then what you've done is you have one application. Well, it's technically a second application because you already had your Canadian one. So then you have one application for all of those 5 foreign jurisdictions. It could be even more. You could have all 120 some odd countries that are part of this treaty. And then that application gets sent by the Canadian office to the World Intellectual Property Office. They review it, make sure everything's in order, and then the World Intellectual Property Office sends the application to the different jurisdictions that you have designated in your international application. And so you didn't need to go into each country directly, and you save yourself the time and the expense of doing so. There is an expense involved in the international registration system. You have to pay the foreign government filing fees, but you're saving money in terms of you don't need to hire an agent in each country. So you're saving legal fees in those cases, and you're bypassing other technical requirements, which can sometimes be required, like translations, powers of attorney, certified copies of your Canadian application. None of that is required when you use the international registration system. So that can be very powerful. It's usually only worthwhile if you're going to be filing in 3 or more, sometimes 5 or more foreign jurisdictions, because otherwise, because there is an initial fee just from the World Intellectual Property Office to use the system. And it's that fee is typically not worthwhile if you're only choosing the United States and the UK. In those cases, it's probably cheaper to go directly. But that's something where you're probably going to want to talk with a trademark agent about what's the best strategy. And then, another thing to take into consideration with your filing strategy is to define your rights. So what do I mean by that? Well, we talked about what does your application look like? It has your trademark, it has the owner, it has the goods and services. So those goods and services are really the scope of your rights. Well, define those rights with the future in mind. So yes, you're using your brand name with t-shirts and water bottles right now, but maybe in the future you're going to start offering Pilates classes and you're going to start selling lanyards and other equipment, maybe some sports equipment, and so now you're increasing the scope of what you could be doing under the brand. You're not doing it yet, but you foresee down the road that you might be doing that. So put it in your application now, because you can't, once you get your registration, you can't just add goods and services to it. If you want to add goods and services to the scope of your protection, you have to file a completely new application, which, that's time consuming, that's money. Might as well do it now to give yourself the broadest scope of protection early, and then you don't have to make changes later. You can make changes later, it's just might as well not if you don't have to. All right, before I move on to the next topic, which is protecting trademarks through use, were there any questions about the filing strategy? I know that can be quite technical and complicated, so I'm happy to clarify any points that might have caused confusion.
I do have a question here, Jamie-Lynn, and the question is, how long does it usually take to fulfill that whole process? So from the start of having the trademark protected, as an example, in Canada, because the person hears that this can be a very long process.
That's an excellent question, and that the person who asked it is not wrong. It can take a long time, particularly in Canada. So it depends on the jurisdictions. So Canada, for example, the time between when you file your application and the government representative picking your application out of the pile and looking at it is currently 30 months, almost 3 years. It's astounding. It's completely unacceptable, and the government knows that, and they are trying to reduce that backlog. But what that means is for filing in Canada, you're looking at an average about 3.5 to 4 years between filing and getting your registration. But you shouldn't be too scared by that. That shouldn't put you off of getting a registration. It's because I said that your rights begin to run from when you're using your mark or from when you file. So just having your application on file is powerful, and it is a right, which can be asserted against other people. And it also gives you that passive enforcement. So yes, you don't have your registration yet, but it's on record, it's there, it's stopping anyone else who comes after you. And hopefully the backlog will be reduced. There is an ability to get what's called expedited examination if you really, really need a registration because you're involved in a court action or you're battling counterfeit products at the Canadian border. In certain specific situations, you can get faster examination, but on average, you're looking at almost 3 years right now. So that's tough. In the United States, the situation is much better. You're probably getting your first examination within 6 months and maybe your registration within a year, assuming that you've started using the mark in the US. So the US, they have a requirement that you actually have been selling your products or offering your services under your trademark in the United States in order to get a registration. Canada has no such requirement, and many jurisdictions don't have that requirement. So it can actually take longer in the US, but that's not the government's fault. That's more your fault if you haven't put your mark into use in the US. But assuming you've used, it can be as quick as 1 year between filing and registration in the US. And then, some countries are very, very quick, and they don't do much substantive examination at all. And some are very, very long. And it's, it depends on the jurisdiction. And all in all, you shouldn't be too concerned about the timeline between filing and registration, because, like I said, your rights begin to run from when you file. Any other questions on the filing strategy topic?
That's it for now. Thank you.
Okay, great, thanks. Okay, So, you searched your mark. Well, firstly, you selected a mark that was strong, not weak, not descriptive. Then you searched it to make sure it was available and that no one else was using it, no one else had registered it. And then you went to the trouble of filing your application and getting your registration. Well, that's done. You're done, right? You've gotten trademark protection and there's nothing else to do. Well, that's not the case. In Canada and in other jurisdictions like the United States, you have to use your trademarks or you lose them. So if you have a registration, that registration could be canceled, expunged, it could be removed, it could be taken away from you, invalidated, canceled, if you haven't used your trademark in Canada for 3 years. So after your trademark registration is 3 years old, anyone could file a letter with the government saying, hey, I think that person needs to prove that their trademark is in use, otherwise it should be canceled. So that could happen at any moment after your trademark registration is 3 years old. And you could be asked at any given time to provide proof that, let's say your trademark is for goods. Well, here you have to provide proof that you sold those goods in Canada with the registered trademark on them. Otherwise, your registration could be canceled. So you use it or you lose it is a doctrine of Canadian trademark law. And so what is use? That's a legal term. It's defined in the Canadian Trademarks Act. Well, with goods, the mark, the trademark, the brand name has to be on the product or on the packaging or otherwise associated. So it could be on a sticker close by, but usually what we're looking for is it has to be on the product or the packaging. And then for services, let's say your trademark is for a restaurant. Well, you don't sell goods. You're supposed to put the trademark on the actual food? No. You have to display the trademark in the performance or advertising of the services. So it's on the signage out front of your building, or it's on your menus, or you've got a TV commercial asking people to come on down to your restaurant, and the trademark is displayed in the advertising. That's how you show use with services. And it's important that you use a trademark as a trademark. So what do I mean by that? Well, you have to make it stand out. And you do that by using a different color, different font, different size, capitalization. You have to set it apart from the surrounding text so it doesn't just look like another word. And you want to use it as an adjective and not a noun. So an example would be, the Galaxy S smartphone is the fastest selling smartphone on the market today. And you wouldn't want to say something along the lines of, the Galaxy S is the fastest selling smartphone in the market, blah, 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 blah. And, I think that with the case of the Galaxy S, where you've got a very famous trademark, it's the risk is probably lower. But when you are just trying to build your trademark rights, build that brand value that we talked about at the beginning, you want to really make it clear to the public that this is a trademark. This is not the name of your goods. This is a trademark which I'm using to indicate to customers that what they're buying is from me and not from anyone else. So you don't want to change the trademark in any way by adding an S to it and making it plural. Always in the singular if that's what your trademark is. Oh, we have another poll question. Can someone tell me what all these words on this screen have in common? Escalator, linoleum, cellophane, dry ice, kerosene, trampoline, zipper. Were they all inventions that were invented in Canada? Were they all created by the same company? Are they all worth 50 points in Scrabble? Or are they all once trademarks that became generic? All right, the answers are coming in. Got 8 of 19 people have responded. I'm going to give you a few more seconds here. Okay, more than half of you have responded. All right, I think we're going to close it in 5 seconds. 4, 3, 2, 1. Okay, so looks like anyone who answered was right. These are all once trademarks that became generic. So the owners did not take the steps that we just described to make sure that the marks were used as trademarks and not as the product name. So now these are all known as product names. You take an escalator up the stairs. You don't take an escalator elevating device. And so, especially if you are in a very innovative field where you create a new type of product and you have a brand name for that product, you want to be very careful to differentiate between your brand name and what your product is, because otherwise you can lose all rights to your brand name. I recommend to you to go onto YouTube and watch the Don't Say Velcro video. You might have seen it before. Velcro is a trademark belonging to the Velcro company, or I think they're called the Velcro company. They might have another name. And of course, when we think of Velcro, we think of that product, that sticking product, but really the word for it is hook and loop, and Velcro is a trademark belonging to a company. It happens to be the company that invented the product, but now that the patent no longer exists, anyone can sell that product, but not everyone can call it Velcro. So I recommend that you look on YouTube and try to find that video, because it's very funny. It's a very funny music video about how they don't want people to call the hook and loop Velcro because that's a trademark. So that's just a fun example of how companies can educate the public on what a trademark is. Yes, these were all the victims of genericide, as you all accurately guessed. So genericide is like a made-up word, which means that a trademark has been killed because it became generic. So other ways that you can protect your trademarks is by marking. So you've probably seen on product packaging or in advertisements the little TM symbol or the R in the circle. And so you're like, when am I supposed to use that? Do I have to use that? Well, it's a good idea to use it after every trademark, including designs. And then if your mark is registered, use the R instead. So in Canada, there's no real explicit prohibition against using the R if you don't have a registration, but there is in the United States. So just out of an abundance of caution, particularly if you are going to be having some cross-border trade, we recommend only using the R if you have a registration. And otherwise, you can just use the TM. And you don't have to put it every time your trademark appears. You can, and there's some companies that do, particularly if they're worried about their marks becoming generic. But you can use it the first time it appears, and then you don't need to use it afterwards. You can do an asterisk, and then in the legend say that this is the trademark of this is a registered trademark, or this is a trademark of this company. Maybe it's used under license. So there's no hard and fast rules about the marking requirements. The purpose of them is just to put the public on notice that that is a trademark. It's owned by me or whoever, whatever company, and it's not a generic word. And then, finally, when it comes to protecting your trademarks, you need to monitor, because if other people start using your trademark or something that is very similar to your trademark or brand name for the same or similar goods or services, it can that mark stops pointing to you, and it starts pointing to, it doesn't point to any company in particular. It becomes non-distinctive. You've lost that strength that you once had. And so what you need to do is you want to monitor the Trademarks Office databases for new applications and monitor the marketplace for infringement, confusing use, or generic use. And when you spot issues, confusing trademarks being used or applied to be registered, you have to, send demand letters. You want to capture these. I think that's in my next slide, so I won't. Yeah, that's the enforcement slide. So you want to put in policy a place for. You want to put in place, pardon me, a policy for capturing those that third-party confusing use, infringing use, generic use. And then once that use is identified, you want to take steps to enforce your rights. So it's always a good idea before you send your cease and desist letter to get an opinion, because maybe it's not a great idea to do so. Maybe your rights aren't as strong as you thought they were. Maybe you don't quite understand the confusion analysis, and this isn't really a legal issue at all. But if it is, your legal counsel can advise you, and maybe the next step is to write a demand letter. And then if the infringing party doesn't stop, then you might only be left with launching a lawsuit in court. But there's things that you need to consider before you do that. Threat to your rights. If you don't take that action, like I said, you could lose distinctiveness, you could lose the ability to enforce your trademark at all. And also it's a threat to the business. If you've got a competitor that's using a confusing mark, they could be directing revenue away from you and towards themselves. You don't want that. But then you have to weigh that with the legal costs of hiring legal counsel to give you the opinion, to write the demand letter for you. There could be a potential counterclaim against you. Maybe you don't have the rights that you thought you did, and they have the better rights. There could be bad publicity particularly if you're a big company and you're seen to be picking on a small company. Even if you are legally in the right, that demand letter could end up on the news. My colleagues have had demand letters that they've written on behalf of clients end up in the news, and you just look like you're a bully, and that can be bad publicity, particularly if your brand identity is about cooperation and not being a trademark troll. And of course, you have to consider the time and energy involved in trademark enforcement or IP enforcement in general. Even if you're in the right, even if you're very likely to win the action, it takes a lot of time away from your business to put together the legal case, to put your evidence in. And that's time that you could spend working on your business and making your product better, increasing your customer base. So those are all considerations to balance when thinking about trademark enforcement. So before I move on to our very last topic, I'm going to pause and again open up to questions about, protecting your trademarks and how you should do that. Were there any questions on that topic?
I do have one here. So if your business name is registered in Ontario, can you use the R symbol?
Right. So that's a great question. Again, in Canada, there's no rules. Pardon me, I'm losing my voice. In Canada, there's no rules about using the R. So you could use it and there'd probably be no ramifications, but that's really not what it's intended for. The R is it denotes, that you have a registered trademark and not a registered business name. So those are two separate concepts. Again, it goes back to the very beginning when we talked about the distinction between a trade name and a trademark. So your trade name, your company name, which is registered in Ontario, it could also be a trademark. But if you've not gone to the process of registering that trademark with the Canadian Intellectual Property Office, you don't have a registered trademark. And you probably shouldn't use the R in Canada, and you definitely shouldn't use the R in the United States. But you can use the TM if indeed your business name is also your trademark. There's nothing against doing that.
That's it for now. Thank you.
Great. All right, so on to our next topic. And after that, it's a very brief topic. And then we can open it up for just more general questions. Oh, I think now I'm remembering. I promised to give you cost quotes for the filing strategy. So if we're looking at Canada and we're filing one trademark, and it's for a fairly limited list of goods and services, because the more types of goods and services you include, the more expensive the application becomes. So let's say you've got a word mark and it's for t-shirts and you're filing only in Canada and you do it yourself. It's a fairly inexpensive process. You can go online, you can file the application, and you just pay the government fee. And the government fee is the government increased their fees recently, but instead of having to go through the approval process to increase them by normal amounts, they took advantage of a loophole which allows them to bypass the approval process if they only increase by a certain percentage. So as a result, the filing fees are no longer nice round numbers like $350 or $330, I think it used to be. Now it's like $336.16 or something ridiculous. So you'll have to forgive me for not knowing the exact number off the top of my head, but it's between $300 and $400 for the government filing fee. And so if you do that yourself and you don't hire a trademark agent, that's how much you're paying. If you have different types of goods and services in that application, that's going to increase the cost by $100 for each class. So all the goods and services in the world have been classified into 45 neat categories of what are called classes. And these classes are used around the world. They're sometimes referred to as nice classes based on the treaty, which was signed to bring all to make this all uniform. So, for example, perfume is in class 3 and clothing is in class 25 and retail services are in class 35. And so you have all of those in an application, that's 3 classes. So your first class is covered by your initial filing fee of $340 or whatever it is. And then let's say you're adding perfume now, that's another $102. And then you're adding services, that's another $102. So those are all filing fees. If you're going to secure the services of a trademark agent to help you, you're going to have the filing fees, and then you're going to have the legal fees in addition to that. And, I think if we're looking at just a one-class application, you're talking at around $800 for our assistants to prepare and file the application on your behalf. And then that's just for the application. That's not the registration. Well, let's say you're doing it yourself and the application runs into no issues whatsoever. The office simply approves it. It's advertised. There's no oppositions, and you get your registration. There's no other costs. That's the filing fee, and that's it. If you have our assistance and there's no issues that you run into, well, then it's about another $850 for us to report each step to you along the way. And then, so, I typically tell, so if you're hiring us to do it, I tell clients to budget around $2,000 if they're going to work with us to file their application, from application all the way through to registration. So that's about $1,000 up front and $1,000 near the end. And that's if nothing pops up. Of course, it's often the case that issues arise during examination, in which case you can respond to them yourself, or you can get a trademark agent. And let's say there's an objection that you need to deal with. You need to argue that the mark is not confusing with one that the examiner has found. Well, that can be another $1,000 there for us, but there's no, if you're doing it yourself, there would be no government fee. So those are just some ballpark figures on the costs in Canada. The United States, I'd say it's probably, just double it. Just things are more expensive there, including the fact that you have the exchange rate. Yeah, so I hope that gives context. But now moving on to the how to create exclusivity in a crowded industry. You think about exclusivity in the product itself, and that would be what a patent is for. So you want to try to prevent people from selling the same product as you. That can't be done unless you have a patent over some sort of useful aspect of the product. So trademark doesn't really do that, but you can try to get that exclusivity through trademarks. And so I'm going to give you a little example. Chrysler owns the trademark Stow and Go for that aspect of their minivans where the seat can be pushed down and put all the way lying flat. Honda has the same product, but it's called Magic Seat. And there's no exclusivity over the product itself or that feature of the minivan. Both companies do the exact same thing. But the way they market it as the Stow and Go seat. That's what Chrysler does, or Honda markets it as the Magic Seat. And so in your marketing, you can say, we are the only minivan that has Stow and Go. And that's because they have a trademark for Stow and Go and no one else can use it. And so, you can use trademark rights in sort of a creative way to create exclusivity over a product which everyone has. But if you market it well enough and it becomes well enough known, then people are going to ask for the Stow and Go seat, and so they're going to be asking for your product, not for other people's. So that brings me to the end of my scripted comments. I think we have 10 more minutes left for just open questions on anything that we talked about, or if you have questions about trademarks or IP generally. I won't admit to knowing much about patents, so try not to ask me anything about that. But my colleagues are frequently doing these master classes and are available for our IP clinics, and some of my patent colleagues, I'm sure, would be happy to answer those questions in those forums. Do we have any questions?
We do. So one question that I have here is, where did you say we can complete the registration ourselves, get the list of product categories and that can be trademarketed and find the cost for that self-registration?
So that's all. That'll all be on the Canadian Trademarks Office website. I don't know the domain name off the top of my head. Why don't I'm going to stop my screen share for a moment, and if you'll bear with me, I will. So now you can see me, and I'm going to pull up. Yeah, it's not a very. Leah, am I able to post a link into the chat here?
Absolutely. Yes, you
Let's
can.
see. Okay, so this is the link. As you can see why I didn't read it out, because it's a bit of a garbled mumbo jumbo. But essentially, that is, if you click on that link, that will bring you to the Trademarks Office website. And on there, you can, maybe I'll even share my screen right now. There we go. So on there, you can see, you can learn about searching trademarks, searching goods and services. So that will help you find out what classes the different goods and services are in. Here's the link to the fees, preparing your application, how do you apply for your trademark, just some other info documents kind of summarizing a lot of what I talked about today. So there's a lot of good stuff on here, and I'm always happy to point to the government website because, of course, they're the authoritative source on all of that. But yes, that's where you could file for yourself and find out what the fees are and the different classes for the goods and services.
Okay, then I think on my end, I don't have any other questions.
Great.
I'm just gonna have a look again at the chat here to be sure I'm not missing anything. You're getting a lots of thank yous. And actually, if you have a Twitter account, as in a professional setting.
Oh, you know what? Some of my colleagues do, and I don't. I'm not as social media savvy on my professional life as I probably should be. I have a LinkedIn account, and so you can find me on LinkedIn. I welcome you to connect with me on LinkedIn, and I sometimes share insights through that. And you can also sign up to our firm's the Smart and Biggar mailing list, and we also send out articles about interesting things, interesting developments in IP.
Amazing. Well, with that being said, Jamie-Lynn, we are getting a lot of thank yous in the chat. A lot of this was a great section, very informative. So thank you so much.
Oh, it's my absolute pleasure. I appreciate Invest Ottawa putting this on, and I always love connecting with small business people, medium-sized business people, entrepreneurs of all shapes and sizes.
Thank you so much, Jamie-Lynn, and also thank you, Smart and Biggar, for really walking us through these different aspects that we have to keep in mind when it comes to branding and protecting our brand as an entrepreneur. What I will do is I'm going to be following up with an email to everyone who was today or was present in today's session. I'll include a link to the recording and also a link to a feedback survey where I will be very thankful if you could let us know how we did today. And if there are any other topics you'd like to see us cover in the future, because we're here for you today, in the sense we create the content around your needs and wishes. So thank you so much again, Jamie-Lynn. Thank you everyone for being here and take care.
Thanks everyone. Bye.